Hello, everyone. My name is Jean Christensen, and I am a partner at Wigdor LLP. And I am here with two of my colleagues today to answer some of your questions about unemployment insurance and paid leave, as well as new laws that have been enacted in the last several weeks, and what these laws mean for people in this current crisis, as well as talking about some of the laws that have been in existence for years to protect employees. Our firm, Wigdor LLP, specializes in representing employees who have been discriminated in the workplace. Discrimination can take many forms, and we represent employees that perhaps have been discriminated based on their race, their religion, their skin color, their gender, perhaps because they spoke out about sexual harassment, and all sorts of things that factor in to the moment we are all in now and experiencing mass layoffs and such. So I'm going to let Julia and Hillary introduce themselves, and then we will get right into talking about the questions that we have received and hopefully helping some people during this hour. Julia?
Hi, everyone. I'm Julia Sachs. I'm an associate at the firm. I've been at Wigdor LLP for about a year and a half. And we're really excited to be able to help people out with any questions they have during these really difficult and uncertain times.
Hi, everyone.
Hillary?
Thanks, Jean. My name is Hillary Orzik. I'm also an associate at the firm. I've been with the firm about 3.5 years. And again, we're just really trying to provide anyone answers for those who have questions in this very, confusing and uncertain time. Just so you know, if you do have questions that you haven't already submitted, you can submit them through our live comment feed. And if you submit the question, then we will read it and we will answer it throughout this portion. So please don't hesitate to ask us any questions. You may have a difficult time doing it from your mobile device, so you may have to log in on your computer in order to submit those questions if you're not seeing that live comment box come up. But thank you all for tuning in, and hopefully we're able to help. And with that, I'll give it back to Jean.
Thank you, Hillary and Julia. So we're here today following up from a session last Friday in which we talked about specifically the new laws for paid sick leave, as well as the current uninsurance laws and any supplements to the uninsurance laws. And I think one thing that has changed between last week and this week is that as of the current figures, right now in the last 21 days, there have been more than 16 million employees throughout the US that have sadly lost their jobs. And while that number is just overwhelming and difficult to digest, the reality right now is that many families are in situations where the income has been cut off. There is a lot of confusion about what rules apply and what people are supposed to do in these situations. That confusion has been compounded in part because many states and cities had protocols in place that have been unable to deal with the sheer volume of people applying for unemployment and people reaching out to the government and to local resources about what they are supposed to do. And so that compounds the confusion for everybody. And until and when these government entities that are passing the laws issue more guidance, some of the questions that are asked today, we're not going to be able to answer completely because the response will be that we don't know. We're waiting for the Department of Labor, for example, to clarify certain provisions in the new laws and such, but we'll do our best. And keeping in mind that things are fact specific as well, we will try to help people understand if we can't answer what they might do or where they might go for more clarity. So I think we can start, Julia, if you want to start on the either existing or the new laws in place to specifically address the changes with the virus.
Yeah, sure. So thanks, Jean. I will go over, again, if you tuned in last week, I'll just be going over the COVID-19 paid sick leave in New York. And I will also be discussing some new guidance that came out yesterday on what constitutes an essential business in New York. So I'm just gonna share my screen here. And so hopefully you all can see the new guidance that came out yesterday in New York that is on Governor Cuomo's Executive Order 202.6, defining an essential business, which we got a lot of questions about last week as people are wondering whether they work in what would be defined as an essential business. So, of course, many people know or would understand that essential healthcare operations today are extremely essential. So anyone that works in a hospital or a medical supplies and equipment manufacturer, those types of businesses are considered essential, and people have to report to work, even if they're worried, which is a very valid fear and concern that they might get sick or might get the virus. There's also essential infrastructure, which includes public and private utilities, airlines and airports. And I'm not going to read all of them. Obviously, you guys can go on to the governor's website and look at the guidance from this executive order. But just to give a few more examples, essential manufacturing, which might be food processing. Obviously, people still are grocery shopping, so the food has to get there somehow. The household paper products, toilet paper, and then essential retail, which is of course grocery stores, pharmacies, farmers markets, gas stations, and then some, just to go through some that people might not think of right away when they think of an essential business, would be the news media, but of course we all still need to understand what's going on in the world. And then providers of basic necessities to economically disadvantaged populations. So that would be homeless shelters, food banks, human services providers, so city agencies, that work with homeless or with human resources administration. And then construction, which the governor did put a order out that all non-essential construction must safely shut down, but there is still emergency construction. So if you're a construction worker, this would be a good website to go and look at to understand whether or not your construction project falls into what is considered emergency construction. So that's a new guidance that just came out yesterday. And if people have questions about that, we can go over it during the live stream today. And then I will also go through a little bit of the breakdown of the expansion of paid sick leave in New York. So in New York, to be eligible for paid sick leave, you must work for a company with more than 10 employees or over 1 million in net income in 2019, or you work for a public employer like the city or state or the federal government, and you or your minor dependent child are under a mandatory or precautionary order of quarantine or isolation. And so you're not necessarily entitled to paid sick leave if you don't feel well. However, you only get paid sick leave if you have that mandatory or precautionary order of quarantine. And we can talk about that later if people have questions about what that is. And then depending on your employer's size and annual income, that is what will tell you whether or not, or how many days you are allowed to take off under this new law and legislation. And so, for example, if you work for a private employer that has 100 or more employees, your employer has to provide at least 14 days of fully paid sick leave under this law. And same thing if you work for a public employer. And then the documents that you need to apply for paid sick leave, I'm not sure why it's not, okay. So you will need the documentation of that order of quarantine, which would come from your local health department. And so if you don't know where your local health department is or what that is, you can get an attestation from your doctor stating that you have to be under an order of quarantine, but you still need to be connecting with your local health department or trying to reach your local health department as you provide those documents to your employer. And then you also will need to fill out 2 forms that you can get on our blog or on the New York Department of Labor. And then let's see, can I be fired because I took the COVID-19 quarantine leave? And that's a good question. No, your employer cannot fire you or retaliate you because you took leave. Obviously, you are on this leave because of a mandatory or precautionary order. And so, of course, like social distancing, we want to do everything we can to minimize people getting coronavirus. And so, of course, you cannot be fired or retaliated against. And so I think I'll stop there. And maybe if people have questions later on, we can answer that. And I'll let Hillary continue.
All right, thanks, Julia. So I'm just going to talk briefly about unemployment insurance benefits, what traditional unemployment benefits are, and what the new types of unemployment benefits are for individuals affected by COVID. There are a few different terms, so just to go over some basic terminology, I'm going to be referring to unemployment benefits as, I guess, one of 2 things. So I'll refer to them as traditional unemployment benefits when I'm referring to the unemployment law that predates the CARES Act, which is the legislation that was passed in order to expand unemployment benefits as well as some other items. So there will be traditional unemployment benefits and then the pandemic unemployment assistance. And so both of those are 2 types of unemployment benefits. There's the traditional type and then the new pandemic unemployment assistance, which is provided by the CARES Act. So just by way of background, and I'll go ahead and share my screen too. So the unemployment benefits. So unemployment benefits or unemployment insurance is temporary income. And the purpose of unemployment insurance is to help tide workers over if they've lost their job for a reason that's not their fault until they get their next job. So unemployment insurance is for individuals who lose their job, and as this is the Department of Labor's website, as they say, through no fault of their own. So what does that mean? Through no fault of their own can mean that they were laid off because their workplace has shut down or is not continuing. It could mean that there was a downsizing, and so they were downsized even though there are some other employees that remain working. It could mean someone who simply wasn't meeting performance standards, right? Who the employer decided wasn't, not that they did anything wrong, but they just weren't cut out for this position. Some examples of how you can lose a job that would be considered a fault of your own, and these are just general examples, would be if you committed some sort of misconduct. So if, for example, you were stealing from your employer and your employer caught you, that might be an example of misconduct where you wouldn't be entitled to unemployment benefits if you were terminated for stealing from your employer. Now, traditionally, one would apply for unemployment insurance. It would cover you for about 26 weeks. And then during those 26 weeks, you would have to be actively looking for another job. So you would have to, this is the language from the Department of Labor, to collect benefits, you must be ready, willing, and able to work, actively looking for work during each week in which you are claiming for benefits. So these are all your obligations under the traditional unemployment benefits, or the unemployment benefits that were available to anyone prior to this pandemic. Now, since the pandemic, there's this new act, the CARES Act, and what the CARES Act did was it provided a new type of unemployment benefits, the pandemic unemployment benefits. And so these pandemic unemployment assistance provides unemployment benefits for a number of new categories of employees or instances where people otherwise wouldn't have been eligible for unemployment benefits. So here are some examples of some COVID-related scenarios that are now covered by unemployment, where you can now be entitled to unemployment, where previously under the traditional unemployment benefits, you wouldn't have been eligible. So for example, if you're diagnosed with COVID, or if you have COVID symptoms and you're seeking a diagnosis, you can be eligible for unemployment. If a member of your household has been diagnosed, if you're providing for family or a household member who has been diagnosed, if you're the primary caregiver for children unable to attend school or another facility that's been closed due to COVID, if you're unable to reach your place of employment due to an imposed quarantine, or because you've been advised by a medical provider to self-quarantine due to COVID. And I'm not going to read through all of them, but essentially if something related to COVID is legitimately making it impossible for you to do your job, then you may be entitled to this new pandemic unemployment assistance. There are two categories that the Department of Labor wants to make clear that this new law does not provide unemployment insurance for. And that's, the first one is if individuals can telework with pay. So essentially, if you can do your job remotely, your employer says, please stay home, do your job remotely, I'll continue to pay you to do your job remotely. You can't turn around and say, no, I'm not going to do that. I'd rather just apply for unemployment benefits. Another example is an individual receiving paid sick leave or some other paid leave benefits, regardless of meeting a category listed above. So if, for instance, you need to take care of your child because your child has been diagnosed with COVID and you're on paid sick leave, you can't be entitled to unemployment benefits while also being paid to work, have paid sick leave by your employer. And so that's just a little bit of the background of the old unemployment, the traditional unemployment benefits, which is still in place, and the new pandemic unemployment assistance, which is now offered to individuals. So at this point, I think it probably makes the most sense to start, unless Jean, did you want to talk?
Yeah, sure. I just wanted to jump in. With all of this, I think it's important for people watching to understand that one of the reasons we at Wigdor LLP think it's important that we're having these question and answer sessions is that we know from our work in this area that whenever there is an economic downturn, there is a direct correlation between that downturn and an uptick in discrimination that takes place in the workforce. Unfortunately, the historical truth of this is well documented, and primarily people that serve in low wage, minimum wage, temporary workers tend to be the most impacted in this situation. And they're also the ones that these laws that have been around for years were meant to protect. But sadly, bias does factor in to decisions in economic downturns about who is going to be laid off first, who's going to be furloughed versus final termination, whose hours are going to be cut, and questions like that. And so we are sensitive to this, and we've handled many cases in situations where an employer tries to claim that the reason somebody was let go was because of financial hardship, when in fact, this employee was somebody that the employer wanted to let go for reasons that violate our anti-discrimination laws. That is, perhaps the employee is pregnant, or perhaps the employee has spoken out previously about rules that they didn't think were fair, or things that somehow violated their rights, and the employer wants to let them go in retaliation, as opposed to some objective metrics about who is supposed to be let go first. So that's something that the answers to questions like that from people would be fact specific and depending on somebody's situation, but we certainly know that this is going on. And if anyone has questions about that during the session, we're more than able to address them to the best ability now, and then direct them about follow-up. So with that in mind, we have already received some questions, and I will just direct them to Julia or Hillary, depending on the specific topic. The first is, I am an employee that works in a cafeteria for an employer in the healthcare industry. I am afraid to go to work because many of my coworkers have become sick with the virus. Am I allowed to stay home? So Julia, would you like to be the first to respond to that?
Sure. So obviously, this is an understandable concern that I think many employees are facing, especially essential workers, and an employee that works for in the cafeteria for an employer in the healthcare industry, probably a hospital or a medical facility, would constitute an essential employee under the guidelines. And so unfortunately, under the guidelines, you do have to go to work, unless, of course, you are under a mandatory or precautionary order of quarantine, or you can take your regular paid sick leave that your employer usually gives you if you're feeling sick. But unfortunately, just being afraid of getting the virus, which is a very valid fear, is not a reason that you cannot show up to work. And if you refuse to go in, then it's very possible that your employer could, in fact, fire you.
Thank you. And then just as a follow-up to that, there's another question. I suppose we could use, even if it was somebody in the cafeteria at a hospital as opposed to a nurse or a physician, but somebody asks, can my employer penalize me if I complain about not having enough protection, such as masks, gloves, and gowns?
Yeah, so I've heard about this issue from many people in hospitals, and as everyone knows, a lot of hospital workers are facing this exact issue. The governor has asked for creative industries to make masks and gloves and other protective gear as is possible across the state and across the country. So this too is a very legitimate concern. And I'm sure that people are complaining about it. Unfortunately, your complaint would not be a protected complaint under the discrimination laws. And if you went and complained about it, there's nothing protecting you from getting fired or from your employer being upset with you for complaining. It's very possible that your employer is doing everything they can to get the protective gear to the facility in question. So it is possible, obviously it's very fact specific, but it is very possible that your employer could penalize you for complaining about this issue.
Thank you, Julia.
I also just want to add to that. There are whistleblower laws in place in New York, and keep in mind that every state has different whistleblower laws. So if you're watching this and you're from outside New York, then there might be additional laws that apply to you. And we highly, please feel free to follow up if you're from a different state or if you have questions about the complaints that you want to make. There are whistleblower protections here in New York for healthcare workers, specifically complaining about the safety of patient care. And if people have questions about that, please, don't hesitate to follow up and let us know. So unfortunately, the whistleblower laws in New York are not the most robust of all of the states, but New York does have certain laws that can protect healthcare workers depending on the kind of complaint that they're making. So you want to be careful when you're considering what type of complaint it is, why you're complaining about it, and we definitely recommend that you speak to an attorney to see what types of complaints are protected and what types of complaints are not necessarily protected.
Thank you, Hillary. And I think you're probably in the position to best respond to the next question that I'm seeing here. Somebody asks, can I get unemployment insurance if I am furloughed?
Sure. So first of all, it depends. But generally speaking, if someone has lost their job, even if it's only temporary, then you can still apply for unemployment insurance. When you do that application, when you fill it out online, then you want to make sure that you are being transparent in what your employer has told you and that you're being honest. However, many American workers are experiencing the same situation where they've been told not to come back for a month, for 2 months, something like that. And the Department of Labor wants to make sure that individuals who either, are at a loss for income for a month or two, or for an uncertain amount of time, can have coverage. So you want to make sure to include all of that information when you're certifying for benefits, and then to also make sure that you know what your obligations are for looking for other work. Because depending on how long your furlough is, depending on when your employer has said you can expect to return to work, you may or may not have an obligation to look for other work. So you want to pay special attention to those obligations when you are filing for benefits and when you're certifying for benefits.
Thank you, Hillary. And did you just previously mention, I think the New York State just in the last 48 hours has tried to make some adjustments to how their office is fielding calls and applications for the uninsurance benefits?
Yes. So actually it was as of 7 p.m. last night, they instituted a new online portal for individuals who are applying for benefits. So this portal, to the best of my understanding, and again, it was only put online a few hours ago, but the way that it works is that this is available for individuals who are applying for unemployment benefits for the first time. And I can do a screen share here to show everyone exactly what I'm talking about. So it should be this. So if you take a look, let's see. Oh, here it is. Okay. So if you go to the Department of Labor's page on unemployment benefits now, you'll see a number of different new, little boxes with new information that's available. And the first one in this red box is about how you can file a new claim for unemployment insurance through the improved online filing system. And then it gives you a link to file the claim here. It says in bold, this is only for new claims. If you already have a claim, you have to continue making your weekly certifications the way that you have been. So please, if you've already filed, don't file again. You just have to keep certifying every week, even if your application has not yet been approved and is still pending. It says also that New Yorkers who have already filed partial claims under the old UI system and were told to call the call center to finish their application should not. And instead, the Department of Labor call center will call these New Yorkers directly. So hopefully the way that this new system will be implemented, you don't have to have, your phone on hold for hours and hours at a time, hoping that someone at the Department of Labor will pick up. And instead, someone at the Department of Labor will contact you. So if you have any questions, I would highly encourage you look on the Department of Labor's website. If you click on this, it will give you the opportunity to log in and fill out the application through a new online portal, which hopefully will be a little bit smoother and allow for faster response rate from the Department of Labor.
Thank you, Hillary. And again, we understand that this is a situation that New York State and their unemployment board has never experienced before. They've gone from what is in the, I think, 30 to 40,000 range of what their servers are able to handle to now over 1 million people trying to access, trying to file things online. And previously, all applications then had to be followed up with a human being that works for the unemployment. And that, for obvious reasons, is something that has led to reports online of horrific hundreds and hundreds of telephone calls that people have tried to make and not being able to get through to any person there. So we certainly hope that this helps alleviate some of that frustration in an already stressful situation. Moving on, we're getting some other questions here, and somebody's writing in that she works for an employer who, as part of my department's regular weekly wages, include scheduled hours that are classified as overtime hours. But now my employer is claiming that they only have to pay the regular 40-hour week with no classified overtime. That's, well, the answer will depend on the specifics of that situation, but the overtime laws are fairly clear and have been around a long time. We've represented a lot of employees in cases against companies that have violated their overtime laws. We filed class actions on behalf of restaurant workers, for example, who are being denied overtime when they deserve overtime, or otherwise having tipped wages illegally withheld from them. But here, it's not clear just based on what we know in this question, but there's potentially violations of the laws if, for example, this employer has improperly been using overtime wages to compensate their employees. And now it appears that the employee is only receiving what we would call straight time, meaning an hourly wage, not an hour and a half. And I don't know if this person's hours have been reduced. And so previously, if they were working 40 hours and now they're only working 25, it would seem fair and reasonable that their wages are actually being reduced as well. But I would advise this person obviously to follow up perhaps after this session with one of us, but that to really examine why it is that if they're only working 40 hours, they're being paid time and a half right now. So the next question, and this for people that have been able to transition to some sort of work arrangement where they can remotely perform their job duties. This person writes, I have been remotely working from home, but I need to take care of my mother who has been seriously ill with the coronavirus. Can I go on leave? And if so, for how long? And will I be paid? So Julia, would you like to take the first response to that?
Yep, sure. So if you have to take care of a family member that is not your dependent child, then you qualify for family care, which is different from the paid COVID-19 legislation that I spoke about earlier. So you can go onto the paidfamilyleave.newyork.gov website to find out what forms exactly you need to apply, and you can take this leave for family members that include your spouse, your mother, like in the question, or any parent or step-parent or parent-in-law. And you may be eligible to take up to 10 weeks of paid family leave. And it depends on how much you get paid, but you would have to apply through your employer's insurance carrier to see whether or not you qualify. And I can provide this information to the person who asked the question if they want to apply or look on the Department of Labor's website.
Okay, thank you, Julia. And perhaps, Hillary, you can answer the next question that came in. Generally, do you have any insights for people who are self-employed or who are paid on 1099 in terms of the new unemployment insurance benefits?
Sure. And I'll take each of these in kind. So with respect to independent contractors or those paid on a 1099. So if you are paid on a 1099 or you are an independent contractor, then you may have been eligible for traditional unemployment benefits, and you may not have. And so simply because you're paid on a 1099, or simply because your employer has referred to you as an independent contractor, doesn't mean that you are considered an independent contractor under the unemployment insurance law. And I'll share my screen here because the Department of Labor, on their website, under the frequently asked questions, one section is called UI and independent contractors. And I highly recommend you take a look at this page because individuals who are paid on a 1099 or who are called independent contractors may still be eligible for traditional unemployment benefits and may still be considered an employee under the unemployment insurance law. And just to take a step back, the definition of an employee versus an independent contractor under the unemployment insurance law is different than the definition of an employee or independent contractor under some other laws. So for instance, under the minimum wage law or the overtime laws. So just make sure that you're actually looking at the Department of Labor's website and not some other source, so that you're sure that what you're reading as the definition of an employee or an independent contractor specifically reads relates to unemployment insurance benefits and not some other type of law or benefit that you might be qualified for. So if you're paid on a 1099, but there are some other factors. So for instance, someone who has supervision, direction, and control from their employer may still be an employee in the eyes of the Department of Labor. So you may want to take a look at some of these factors that are included on the Department of Labor's website. Here, there's a list here. And so you may want to take a look and see whether or not you could be eligible for traditional unemployment benefits. However, even if you would not qualify, if these factors don't apply to you, if you wouldn't qualify for traditional unemployment benefits, or if you're an independent contractor, or if you're self-employed, you're now likely eligible under the new pandemic unemployment assistance program. So just taking a look at this, so you'll see here that traditional categories of employees who used to not be eligible for any unemployment can now potentially be eligible under the pandemic unemployment assistance. And that includes self-employed individuals, independent contractors, 1099 filers, farmers who have been affected by COVID. So again, this law is in addition to the unemployment insurance law, the traditional one. So if you weren't eligible for traditional unemployment benefits, then in order to be eligible for these new benefits, you need to in some way be affected by COVID. So just keep that in mind when you're making your application. And the Department of Labor also has specific instructions available to it for individuals who are self-employed. And it goes kind of as a step-by-step on what to do if you are self-employed and how to answer certain questions. So I highly advise that you look at the unemployment insurance website and follow their guidance and the steps that they suggest you take. One other thing just about the application is that when you are applying, when you're applying for unemployment benefits, what you need to do, even if you know that you're not eligible for traditional unemployment benefits and you are eligible for pandemic unemployment assistance, what the Department of Labor makes you do is kind of, it's a really inefficient system as of right now. But what you need to do, if you're not traditionally eligible for unemployment benefits, you still need to submit a regular application for unemployment benefits. And you do that by going on their new online portal. And so even if you know you're going to be rejected, you should still apply for unemployment benefits, be completely honest in giving your responses. And then once the Department of Labor finds that you're not eligible, at that point, you'll have the opportunity to apply for the pandemic unemployment assistance. So just keep in mind, try not to look for a specific application. If you haven't applied for anything yet, you're not going to find an application specifically for the pandemic unemployment assistance. You have to go through the traditional unemployment benefits online portal, answer those questions, have the Department of Labor say that you're disqualified, and then you can apply for pandemic unemployment assistance.
Thank you, Hillary. That was extremely helpful. We have received a number of questions that seem to fall in the same general category. So I'm going to consolidate some of them in this overview question that relates to what employees are required to disclose to their employers about their own health or perhaps the health of a family member, because there's numerous federal, state, and municipal laws that have been in effect for years that protect employees so that they do not have to disclose to their employers about underlying medical conditions, for example, or what specifically is happening that is requiring somebody to ask to go on medical leave. And so there's more than we can talk about in this session, reasons why those laws are incredibly important to protect employees, and what happens and what kind of discrimination goes on when, unfortunately, an employer finds out something about perhaps a chronic condition of an employee, and then suddenly that employee finds themselves as the first one to be part of a reduction in force several months later. But we are in a very unique situation right now, and there have been a lot of questions from employees about what they need to tell their employer, and specifically, do I need to tell my employer that I have the virus? And so the answer is it depends. Most likely depends on what your current situation is and what type of job you have, and how much you're interacting or did interact with other employees. But based on the guidance that's coming out, and there's updated guidance daily on these issues, and we will try to keep everybody informed about these updates. But as of now, it appears that employees should be telling their employers that they have tested positive for the virus or are ill with the virus, especially if at some point they were in contact with other employees, because most likely the employer has an obligation to let other employees know that they may have been in proximity with somebody that did in fact contract the virus. It gets more complicated when you start talking about issues relating the person's identity. It's quite clear from all the guidance that the employer should do everything they can to protect the individual's identity who has disclosed that he or she may have the virus. But at the same time, the employer needs to do what it can to protect the health and safety of all of its employees. So that's something, again, people can contact us if they have specific questions on this issue, and we'd be happy to answer them after. And so it looks like we have time for one or two more questions. And this one, perhaps Julia, you can address. Do I qualify for sick leave if I am under mandatory quarantine because someone I live with has tested positive for COVID-19?
Yeah, so that's actually a perfect example of when you would qualify for sick leave. If you are under mandatory quarantine, then you qualify for sick leave. And just to go back as to what a mandatory quarantine is, you would have to get an attestation from a licensed medical provider, such as your doctor, that you have been in close contact with someone who tested positive for COVID-19. So like your roommate or whoever you live with that has it, who is currently in mandatory isolation. And mandatory isolation is defined by the guidelines as you've tested positive for coronavirus, or your testing is unavailable, but you're symptomatic and you've had contact with a known COVID-19 case. So to answer your question, yes, you qualify for sick leave, assuming your employer falls into one of the categories that I previously discussed, and that you can go onto our blog to make sure that your employer falls into one of those categories with the requisite number of employees.
Thank you, Julia. And so here's another question. My employer does not want to say whether I am still on payroll until my employer is sure that they may qualify for one of the new business loans that the federal government is offering. That's a very good question. And this is in reference to several recent federal laws that have just been enacted to try to provide relief to employers. The goal of those laws being to help employers keep as many employees on payroll as possible, to not let people go. And even in certain situations where an employer has let some employees go, if they qualify for certain of these loans, the goal is that the employer can then hire back some of the people that they had to previously let go, and pay them through these government loans. So unfortunately, while the answer would depend on facts that would be specific to the employer and this employee, if it is entirely possible that if the company does qualify for one of these loans, and they didn't violate any of the anti-discrimination laws that we talked about before, in letting the person go in the first place, that it would be lawful. And then once loan money was received, however, though, the employer could hire this person back. And I think this question also raises the issue about the rehiring, because not only do multiple situations exist, unfortunately, for employers to discriminate against employees in the initial layoff decision for unlawful means. Again, if somebody's pregnant, for example, or age, or the color of their skin, or ongoing medical conditions outside of this virus, but chronic conditions, this same employer and could easily have the opportunity to discriminate against somebody again in the rehiring. And that means that the preference perhaps could be made to rehire people that are younger, or that do not have a chronic medical condition, or perhaps have views that align with the employer's religious views. All of these things are fact specific, and we would urge anybody who believes that they're not, even if you're not sure, be in a situation like this, to contact us after, and we'd be happy to go into details about your specific situation. We wouldn't want anybody to be falling in the cracks among reductions in forces and being terminated for reasons that the law clearly says they cannot be. So I think we have time for one more question here. So, and this will probably, perhaps Hillary, you can take the first response at this. Somebody asks writes in rather, that they're an employee at a local golf course in New York. And yesterday, Governor Cuomo clarified a prior executive order in which he has now held that golf course employees are not essential employees, and that golf courses cannot conduct business going forward. So am I being encouraged to be kept around the golf course because it appears that certain members will be continuing to play golf, or will I be fired if I do not go? Well, maybe Julia, were you the one with the update on who's considered an essential employee under the guidelines?
Yes, and that is correct. Governor Cuomo did say yesterday that golf courses are not essential businesses. And so that person can report that to the state and we can provide the website to that person who wrote in for where they can report that suspected workplace violation. Because if you're not an essential employee, then your employer should not be forcing you to come into work. And I don't know if Hillary, if you had anything else to add about that.
Yeah, so I can just give you a quick look at what this would look like. So here, as you'll see, if you have any questions or need to file a complaint because your employer is requiring you to come in despite all of the laws that have been passed, and they give you some examples, the first one being you're being forced to work at a non-essential business, you can file a complaint, and this is what the complaint looks like, just so you know, where you fill out your information. It can be done, this can be done anonymously if that's something that you're more comfortable with. There's also a report that you can file also on this one's on the New York State website. This one's on the Department of Labor website. So you have multiple avenues where you can report your employer if they're essentially breaking the law and telling you to work when you otherwise shouldn't be working.
Thank you, Hillary. So I mean, this hour has gone by extremely quickly, and we are really grateful that people have tuned in and submitted their questions. I hope that we have answered them. And again, we are happy to speak to people one-on-one afterwards. Our information is online. And we also encourage people, even if they miss this specific hour, to go ahead and email us and directly and with any other questions, because we plan on having these sessions every Friday going forward, and to talk about these issues, to talk about any new guidance that has been provided on these laws during the week, which is entirely foreseeable since things are changing on a daily basis here. And we fully believe that more clarification will be coming in the next week, as well as perhaps supplements to some of these new rules and supplements to existing laws, all intended to help companies retain their employees, to keep people working, and to try to navigate these very difficult times right now to the best of everyone's ability. So thank you, Julia and Hillary, and thank you, everyone, and stay safe, and we will speak to you next week.
Thank you.